They ain't got no evidence. They don't got nothing. They can't even place me out here. They don't have no gun, no car, no Keffe D, no nothing. Duane Davis said that, publicly, on camera. 3 months later, a judge ruled that evidence collected from Davis's own home, during a nighttime search his lawyers called illegal, is going in front of a jury. The man says there's nothing. The court says there's enough to try him for murder. August 10, 2026. Clark County District Court, Las Vegas. 30 years after Tupac Shakur was shot on Flamingo Road, someone finally sits in a courtroom to answer for it. The prosecution's entire case rests on words Davis said himself. The defense's entire case rests on proving those words were fiction. Whoever wins that argument wins the trial. Start with the paper trail. In 2019, Davis published a memoir, Compton Street Legend. In it, he described being in the car. In 2018, he sat for USA Network's Unsolved and described it again. Over more than a decade, in interviews with police and with journalists, he placed himself at the scene, again and again, in his own words, on his own terms. Prosecutors aren't building this case on one slip. They're building it on a pattern, the same story, told consistently, across a book, a documentary, and years of interviews, long before anyone charged him with anything. Here's the theory they'll walk the jury through. Davis didn't pull the trigger. His nephew, Orlando Anderson, did, from the back seat of a white Cadillac. Davis was in the front passenger seat. He provided the .40 caliber Glock. He orchestrated it, retaliation for a fight between Anderson and Shakur at a casino hours earlier. Then there's what came out of Davis's own house. In February 2026, a judge ruled that evidence from a nighttime search of his Henderson, Nevada home is admissible. That's not a small ruling. It means the defense's strongest attempt to keep material out of the courtroom already failed. So the prosecution walks in with three things stacked on top of each other. Years of Davis's own words, a weapon and seating theory that matches those words, and physical evidence a judge already said the jury gets to see. Here's the defense's argument that has nothing to do with what Davis said. It's about where he was. They claim a witness, found through a private investigator, can place Davis somewhere other than Las Vegas on September 7, 1996. If that witness holds up under cross-examination, the prosecution's entire pattern of admission theory doesn't matter. You can't convict someone for a murder they weren't present for, no matter what they later said about it. Prosecutors will argue the alibi doesn't hold, that it surfaced decades late, through a hired investigator from a defense that needed one. That fight, over one witness's credibility, may be the single most consequential exchange of the trial. Then there's the argument built entirely around motive, not Davis's motive for the murder, but his motive for talking. Defense attorney Robert Droskovich will argue the memoir, the documentary, the interviews were commercial products. A man built a public persona around a claim of proximity to the most famous unsolved murder in hip-hop, and that persona sold books and landed interviews. Under this theory, Davis wasn't confessing. He was doing what the true crime industry has rewarded for decades, telling the story people wanted to hear, whether or not it happened that way. Legally, this isn't a stretch to make. Prior inconsistent statements made outside of court and outside of oath are the kind of evidence juries are routinely told to weigh with skepticism, and Davis has, at different points, both claimed presence and denied it entirely. The defense also has a name to offer as an alternative. Reggie Wright Jr., former head of Death Row Record Security. Whether that becomes a full counter-theory or simply a seed of reasonable doubt is a decision the defense hasn't had to make publicly yet. And the nighttime search, the one already ruled admissible. The defense says the warrant leaned on what they call a misleading portrait of Davis as armed and dangerous, used to justify entering after dark. They lost that fight, but it's still the argument they'll use to tell the jury, look at how this evidence was gathered before you decide how much to trust it. There is no murder weapon. There is no DNA. There is no eyewitness who puts Davis at the scene. The prosecution is asking 12 people to convict a man of first-degree murder based almost entirely on things he said about himself, things he now says he made up. That's not unprecedented. Convictions built on a defendant's own recorded statements happen, but they carry a specific risk for prosecutors. The standard is beyond a reasonable doubt, and a jury only needs one juror to find the entertainment purposes explanation plausible for this to end in acquittal, not conviction. Legal experts tracking this case are genuinely split. This isn't a trial where one side is quietly expected to win. It comes down to which story the jury finds more believable, that Davis told the truth for over a decade and is lying now to save himself, or that he lied for over a decade and is finally telling the truth. 30 years, one charge, one defendant, no murder weapon, no DNA, a memoir, a documentary, a stack of interviews, and a man who now says all of it was performance. Whatever verdict comes out of that courtroom, it's the only verdict this case will ever produce. No one else has been charged. There is no backup theory waiting in reserve. This is the answer, or there is no answer. Tupac Shakur was 25 years old. If you want the full breakdown of the case before the trial starts, that documentary is already on Cold Verdict. Link in the end screen.